Welcome to this tutorial key points video for the second tutorial in our W201 course. We started off just by reviewing what we'd done before. It's always a very valuable thing to do to review what you've done. Sources were particularly important, and of course conventions. Make sure that you have a good definition of conventions. The classic is that these are non-legal rules but which are regarded as binding by the constitutional actors. We moved on to the key topic of constitutional law, the doctrine of parliamentary sovereignty, and we had a debate. And what I did was to give a quote from Robin Cook. He said in a conference in 1990 that, quote, "There is no more elitist, authoritarian, hierarchical claptrap than the doctrine of parliamentary sovereignty." And I invited two teams to come up with an argument, one on one side, one on the other. Now, it doesn't matter what your own personal conclusion is, but you do need to have a framework for answering any question on this. And Dicey comes in very useful because whether you agree with him or not, he has given an accepted framework that you can found the debate around. And he's saying the three aspects to it. And first of all, Parliament can pass any law that it wants. That's very much in contrast to positions in other countries where the legislature is bound by the constitutional document. But Parliament no such limitations. Secondly, he made the point that Parliament is not bound by its predecessors. So you can't have a Parliament going around saying, right, we're making these changes and they can only be changed by special procedures, if at all. Again, characteristic of many other constitutions, but not ours. And the key word here is entrenchment. And the third was that no court can question what Parliament has done. Now, with these three assertions, weigh them up. Were they ever true? And are they true in light of our membership of the European Union and the impact of incorporating the European Convention on Human Rights? Sorry, I got the camera power lead around my foot, which is why it was jerking there. It's a useful framework. It isn't necessarily to be accepted, but it's a good one for analysing. Some excellent material in your manual and in cases material on parliamentary sovereignty. Quite an important topic. We then moved on to the institutions of government. You need to know your way round government. So we looked at the composition of Parliament, who can't sit in Parliament and why, the makeup of the Commons, the Lords, possible reforms of the House of Lords, the role of the monarch, officials, government and opposition, the usual channels, chairs of committees, and so on. Then we looked at how Parliament scrutinises the executive, the tools of scrutiny, and an assessment of their effectiveness. We reminded ourselves of legislation, the types of legislation, primary and secondary, and the process of creation. We looked at the executive and the structure of the executive, cabinet, ministers, government department, civil service, and we again reminded ourselves from previous studies about the legal system, the court structure, and the role of what is now the Ministry of Justice. You'll find sufficient material in your manuals, but do make sure that you are well familiar with the workings of government. I then made a brief introduction to freedom, the traditional approach, what it was, its strengths and its weaknesses, and how in the late 20th century we moved from that to the European Convention on Human Rights approach, where there are freedoms that are stated. The traditional method was whatever isn't banned is allowed. Now we say actually there are certain freedoms that need specific protection. Make sure that you know the background to the ECHR, who wrote it, why it includes what it does, and the British history of involvement, from inception to allowing access to Strasbourg to the Human Rights Act. Look at the specific rights, and again, you need to know those specific rights. It's not enough, as some people do on television, to say, my human rights have been interfered with, I'm taking this to the European Court of Human Rights. There are specific rights which are protected. There's the balancing concept, which is important, that rights are balanced against other rights, and of course, make sure you know the case law. On to the TMAs. I said something in my last video, so perhaps you might want to go back and look at this for a recap on TMA 1. TMA 2, of course, is a long way away, but I wanted to say a few comments to keep in mind as you read. You need to show in that TMA that you have a good familiarity with specific rights, what they are, and how they are balanced against others' rights. And there's a couple of key cases here, so make sure that you've looked at those in detail. Even better, have a look at the full law report. The Queen, Daly, and the Secretary of State for the Home Department, and the Huang case. And I expect to see some comments on the relevance of those cases. Question 1, about rights under the ECHR. The key question is, does publication of the article amount to an unlawful interference with Mike's rights? And a reasoned conclusion should result from that. Question 2 is about the criminal liability under the Contempt of Court Act 1981. So you need to address in your reading, when does such liability arise, what are the defences under that Act, and any relevant cases. And then you need to relate it to Article 10 rights, the principles for resolving potential conflict, and apply to the problem in hand. Well, thank you for listening to this video, and all the best with your continued reading.